Thank you everyone for joining us today for this webinar. We've had a little break over the summer, but it's lovely to be back doing webinars for everybody again. So today we're going to be covering employment rights for those with leukemia and related blood cancers. And we're very lucky to be joined by someone with a bit more expertise than me in this topic, and that's Simon. But firstly, let me just introduce myself. So I'm Charlotte, I'm the Patient Advocacy Manager at Leukaemia Care, and I will be chatting through today's topic. So Simon, could you just introduce yourself for me briefly?
Yep, thank you, Charlotte. Oh, I can hear an echo. My name's Simon Allen. I'm a senior advisor at ACAS in the East Midlands. My role, generally speaking, is offering training advice, dispute resolution, workplace diagnostics, mediation, that kind of thing. At the minute, we're delivering things digitally, so it's across the country, basically.
Thank you for being here today, Simon. Appreciate your time. So just a little bit more housekeeping before we kick off. So if you want to ask questions, we'd ask you to use the chat function if you can. So that it should be at the bottom of your screen for most people, little speech bubble. Click on that and type in your question. And very keen for you guys to ask the questions that you want to hear the answers to today. We will do our best to answer them. Obviously, if it's too complex to answer in the webinar, we will redirect you elsewhere and we'll give more details on that later on. Just to say that everything we're saying today obviously is appropriate for today. Things may change, especially in a COVID world, and may become out of date very shortly. So just bear that in mind when you're taking things forward. So we're going to kick off with a short presentation from Simon giving a bit of background on rights and sort of some general information, and then we have got some questions already prepared, but as I said, very keen to talk about the topics that everybody here wants to talk about, so pop them in the chat if you've got any questions and we will make sure we answer those. So Simon, could I ask you to start your presentation for me?
Can you see my screen?
Yep, I can see that.
Brilliant. Okay, so thank you for that. I'll work through, as Charlotte says, a few sort of slides that provide an overview as to employment rights. What I will do is start by saying the kind of things I'm talking about today are statutory requirements. So essentially, employers need to comply with these as a legal minimum. Now, the health warning that comes with that is always check your employment contract. The employment contract should never offer less favorable terms than the statutory minimum, but often does offer more favorable terms on some of the things I'm talking about today. So always check your contract is the first piece of advice, if nothing else, that you take from today. So as I say, my name's Simon Allen. I'm a senior advisor in the East Midlands. I cover Leicestershire normally, but since we've joined this strange world in the past 18 months, I've been delivering digital presentations, training, etc. all over the country. I'm going to look at the key, I suppose, main employment issues, but I'm keen to answer the questions that you guys have got as well. So if I start off with statutory sick pay. Now, I'm not going to read the whole slide out because I'm sure you guys can see it and can read it. What I will say is this isn't an area of ACAS expertise. So I can't get into complex scenarios, and there are complex scenarios about how much, if you're working part-time on medical grounds, how much is sick pay, how much is wage, and that kind of thing. So I'll cover the helpline for HMRC shortly. What I will say is, obviously, it's still day one if COVID related. I know that says 4 days. It mentions on there working out your average pay You need, in order to be eligible, you need to be on at least £120 a week. Now, some people's hours will vary. So the way the average week's earnings is calculated is over an 8-week period. And that 8-week period ends on the last day before your absence. So it'll be the 8 weeks prior to that, and an average will be calculated. If you've not worked 8 weeks, it'll be as many weeks as you have worked. There are linking periods when it comes to statutory sick pay. So if you do get regular periods of sickness, they can count as linked. So you don't have to continually navigate the waiting days, if you want to put it that way. To be linked, the periods have to last 4 days or more, and they have to be 8 weeks or less apart in order to link. Statutory sick pay will cease if the linked periods last for 3 years or more. Now, it may be the case that you are still in a position not to return to work when statutory sick pay is running out, because as it says there, it lasts for 28 weeks. So it may be a case that you have to claim benefits on universal credit or employment support allowance. You'll need a form called an SSP1 in order to do that, and you should get that around week 23 of your sick period if you need that. If you've not got it at week 23, request that from your employer. As I say, if you have complex scenarios, or if there's a dispute over statutory payments, in this case statutory sick pay, HMRC, it's really their field of expertise. There's an inquiry line that I've included in this slide, but there's also the disputes team, statutory payments disputes team, and it's worth keeping that number for all sorts of statutory payments if you have queries, because they'll be the people to direct you to. ACAS can give you an overview, but really it's HMRC. Right, so I thought it might be useful to talk about exits, and that is because there may be people considering their options. I have been asked on several occasions around people with ill health if they can request voluntary redundancy as an option, because they like the idea of the redundancy settlement. Now, what I'll say there is it's not necessarily that straightforward. There has to be what we call a genuine redundancy situation. And by that, laid down in law, it has to meet a definition, and there are 4 elements to that definition that it needs to comply with. So it's either that the business is closing, which is the obvious one, or it's that a particular site, a workplace, or a location is closing, or it's that there's a diminishing need for workers, employees, to do the available work, full stop, or that diminishing need in a particular location. It has to meet one of those criteria in order for it to be a redundancy. And only if there's a redundancy situation, a genuine redundancy situation, can you then put yourself forward for voluntary redundancy. So wanting to retire early or wanting to take the exit and merely suggesting voluntary redundancy is probably not an option. Now, it may be that ill health retirement is something to consider. And again, this isn't an area of expertise, but what I will say is, and I've put that quote in from HMRC guidance, you need to speak to your pension provider. You also need to check with HMRC what their rules are, because there could be quite significant consequences in terms of tax. You may also need legal advice. And obviously, if you are feeling sort of maneuvered out of a workplace because of disability, for instance, then legal advice is essential. In terms of the HMRC guidance, you can take money from your pension pot, but it depends on your pension scheme's rules, and it's usually after the age of 55. You might be able to take money out before this age if you're retiring due to ill health and you're retiring early, or there is some existing right in your existing pension scheme. So it's essential to check with either. Now, according to HMRC guidance, if your life expectancy is less than a year, you might be able to take a lump sum of your pension scheme. the criteria for that, my understanding is you're expected to live for less than a year because of serious illness, and you're under 75. Now, there is something about savings in your pension pot, but it's about £1 million. It's just over £1 million. Also, again, reasons to check with HMRC. If you're over 75, there are significant tax implications on that lump sum. My understanding is you'd have to pay income tax. But early retirement due to ill health, variations of that phrase, may be an option. If you feel you are being maneuvered towards redundancy and it's not what you want, and there are many people in that position, and I get that, things to look out for would be, again, is it a genuine redundancy situation? You can't be made redundant just because your situation takes a lot of managing. So does it meet that definition? Don't forget, it's the position that's being made redundant, not the person. It's the role in the workplace. And then if that is the case and you have been selected, I would look at the selection criteria. Well, I'd look at the pool of people at risk of redundancy and if you are genuinely part of that. But I would look specifically at the criteria used to select people for redundancy. Now, that is one of the areas, one of the pieces of information that has to be disclosed during consultation. And if you're being made redundant, you have to be consulted. So if it's less than 20 people in your workplace that have been made redundant, consultation takes place individually, so on a one-to-one basis. And all the law says that it has to happen in good time. If there are between 20 and 99 people being made redundant, that redundancy consultation is what we call collective consultation, and it has to last at least 30 days. If there are more than 100 people being made redundant, that period extends to 45 days. Now, that can end earlier if you agree. If it's been exhausted and there's nowhere else to go, then it can end earlier, but it can't be ended earlier purely because the employer doesn't like it. So is consultation happening? And also, is it genuine, meaningful consultation? Is another thing. Genuine, meaningful consultation is we're taking into account your views, we're looking for alternatives to redundancy, we're looking to mitigate the impact of the redundancy before we've actually made the decision. If it seems like a decision's already been made and consultation is a box ticking exercise, then that can be challenged. And there's something called a protective award, and that is up to 90 days pay for each affected person. So that is if consultation ends early without agreement, if it starts too late, if you've not had the opportunity to be an employment rep, an employee rep, and if consultation is not meaningful. But going back to the selection criteria, look at how you've been selected and look for signs of discrimination. People are protected in the workplace against discrimination. And it might be, there should be clear, transparent methods of selecting the people to be made redundant. And it should be made clear during that consultation period what those methods are so that you can discuss them, maybe ask questions about them, maybe challenge them. And there can be signs of indirect discrimination. So if, for instance, you've been off ill for a period of time and your employer is looking at the past 12 months performance or the past 12 months attendance, and you've not been in the workplace for 9 months, that puts you at a disadvantage. So if that is not taken into account, and in terms of employment law, you're defined as disabled, and I'll come on to what that definition is. Because if I talk about people having a disability, that's not a label or a judgment, that's in terms of the legal definition of employment law disability. If you are classed as disabled, quite often the periods that are due to that disability should be discounted. Otherwise, you're being put at a disadvantage. And that is the whole point of the discrimination law. I hope that makes sense. Happy to take questions afterwards, as I say. So looking at resolving disputes in the workplace, which I thought might be useful, ACAS advise on good practice. So you've got the statutory minimum legal requirements, and on top of that, what makes that more effective? What can you do to build on that in a more effective way for good work in employment relations? Now, we'd expect any disputes in the workplace to be resolved informally. That's not just ACAS. ACAS code of practice is guidance as to what's a reasonable procedure. So the employment tribunals also expect informal processes to have been followed first. They don't want either the employee or the employer to appear to be in a rush to enter into the formal process, because that might give the appearance that actually the employer, for instance, is in a rush to dismiss somebody. So they'd expect to see some form of informal approach. Speak to your line manager. If your line manager is not the appropriate person, if your dispute is about your line manager, what's the process in terms of raising complaints internally? It's important that your place of work follows its own policies and procedures as well as good practice. So if you end up having to raise a formal grievance, so you speak to your manager or whoever it may be, and you can't reach an informal resolution after a quick chat, it might be that you have to follow the formal process. All workplaces should have a formal grievance procedure, and it has to follow good practice. So that means that once you've made it clear that you're raising a grievance, it's dealt with in good time. So no unreasonable delays. The facts are established, of the facts of your complaint. So if you're raised a complaint, you should expect some form of investigation. Now, normally that would be a separate investigation. Okay, I've raised my grievance. Here's the investigation to establish the facts. Here's the hearing for the grievance based on the evidence from the investigation. Now, in terms of the grievance, accompaniment rules apply. So you have the employer has the duty to allow you to be accompanied by a trade union rep or a colleague. For investigations, it's not as clear. Normally we'd say it depends on the policy of the workplace as to whether you can be accompanied, but that's slightly different for grievances. The expectation during grievances is that during the investigation part of the process, you're allowed accompaniment as well. So the investigation has to be impartial. It's there to establish the facts. It's not there to make the decision. It's there to see if there's a case to answer and then pass the facts over to the hearing itself. There is a balance of probabilities, burden of proof. Sorry to be legalistic about it, but it's a case of, okay, here's a complaint. Is it more likely than not to have happened? And that is how they decide to uphold your grievance or not. So if it's a grievance around discrimination, what's the burden of evidence? Are there as many witnesses to support it as there are against it? That kind of thing. It's a balance of probabilities. It's not beyond all reasonable doubt. So that's the level of proof they're looking for. Now, there should be an investigation. It should be impartial. You should get to see the details. You should be allowed to be accompanied, and if the grievance doesn't go in your favor, you should be allowed to appeal. And that's based on natural justice and essentially the principle of fairness. And again, during the appeal, you've got the legal right to accompaniment, colleague or trade union rep, and the grievance should be heard by an impartial party, so someone other than the person that heard the grievance. If you're appealing against the grievance, how impartial is it that the same person looks at your appeal? And again, the appeal should be heard without unreasonable delay. Now, if the appeal is unsuccessful, or the appeal or the grievance is successful, but there are still strained relationships, it's worth considering mediation. Mediation is useful when you want to stay in the workplace, but the relationships are damaged. You can get an impartial party. ACAS do it all the time, but it doesn't have to be ACAS. Can come in and facilitate a conversation to try and resolve whatever disputes there are between the two parties. Other than mediation, you might have to take it to the next stage, and the next stage would be an employment tribunal, which is basically the court for employment rights. Now you have to fill in an ET1, and you have to it has to meet what they call certain jurisdictions. So there are certain laws that it has to comply with. Now, the best thing to do, if in doubt, now that you don't have to pay, because a couple of years ago there was a fee attached to employment tribunals, and needless to say, the volumes of people raised in tribunal claims disappeared, but the fee's been removed, and now they're back to, well, they're probably exceeding the volumes that prior to that rule change. But there are certain time limits involved, so I'll just run through some of the statutory protections and what the time limits are. So you've got the right not to suffer a detriment in relation to health and safety, and I'll touch on section 44 of the Employment Rights Act shortly. But that means that there is an expectation that your health and safety is protected. And if you raise a complaint against that, you shouldn't be suffering a detriment. Now, there's a 3-month time limit on raising a complaint about that in a employment tribunal. You have the right not to suffer a detriment in terms of protected disclosures. Now, that is whistleblowing essentially. Again, day one right. So you don't have to serve a certain period of time before you can apply. It's a day one protection, but there's a 3-month time limit. You also have the right not to suffer a detriment in relation to being accompanied to a grievance. I've mentioned grievances and your right to be accompanied. If you request that right and you're not allowed to, it's refused, or you're put at a disadvantage merely for requesting it, you're allowed to challenge that. Again, day one right, 3-month time period. Now, you're also protected from unlawful deduction from wages, which might come into the statutory sick pay element or contractual sick pay. Again, 3 months to claim. You're protected from discrimination. So you're protected from unfair treatment if you are in a protected group, and those groups are defined by certain characteristics. So there are 9 of them: age, disability, gender reassignment, marriage, civil partnership, pregnancy and maternity, race, religion or belief, sex, sexual orientation. Now, obviously, on a discussion like this, it's likely to be disability. And as I say, I'll come on to the definition of disability. It could be others, but you're protected from unfair treatment on the grounds of those characteristics. Now, that's the day one right, again. And again, it's a 3-month time limit. There are exceptions where the tribunal can extend the time limits. In some cases, it's where it was not practicable for you to submit your evidence in time, but you have to demonstrate that that was the case. But in other cases, such as discrimination, the employment tribunal can extend the time limit if they think it's what they call just and equitable to do so. So that's up to the tribunal judge to decide. Unfair dismissal. You're protected from unfair dismissal either on the grounds of capability, conduct, issues around redundancy, some other substantial reason, which isn't as much of a loophole as it might sound. Again, there's a 3-month time limit. Now, there is a period of time that you have to serve. So you have to have been employed for 2 years continuously to be able to claim unfair dismissal. So that's something to bear in mind. Now, breach of contract claims, and I'll come on to breach of contract, I think, in some of the questions, I'm not sure, often may be part of a constructive dismissal claim, for instance. So if you're making a constructive dismissal claim and your grounds for your constructive dismissal is a breach of your contract, and I'll come on to that later, you have 6 weeks. This is going to get slightly complicated, but this is all on ACAS and the Cloisters website. So you have 6 weeks from the time you've raised your tribunal claim to add breach of contract to that claim. If it's a constructive dismissal claim, again, you've got 3 months time limit. So 3 months after the act of when you had to resign, you have 3 months within which to submit a claim. But again, for constructive dismissal, you have to have been continuously employed for 2 years. So again, worth bearing in mind. If you're considering these, there's lots of information on the ACAS website. There's lots of information out there in terms of time limits, particularly around constructive dismissal. Legal advice is key. Right, so I'm going to talk about disability. And the reason I'm talking about disability is because the nature of this webinar is around blood cancer. Now, the Equalities Act from 2010, same act that features discrimination, harassment, that kind of thing, also defines disability. Now, the law normally means that you have to have a substantial impairment on your day-to-day activities, and it has to be long-term. Long-term normally meaning 12 months or more. And it's about affecting day-to-day activities, not work activities. However, some illnesses, cancer included, are covered from diagnosis, not the point where their effects are substantial. So essentially, they're covered from day one, from diagnosis. Now, there was a case, if you're interested in case law, it may just be the ANARACs from ACAS that are interested by this kind of thing, but there is a case, Lofty versus Hamis, Hamis from 2018, and that was a case where a person with, I believe it was skin cancer, was dismissed on the grounds of attendance. And they took it to a tribunal claiming it was discrimination on grounds of disability. And it was argued that because their cancer was precancerous lesions, it didn't yet qualify as a disability. This went all the way to the appeals tribunal, which is the next stage from a tribunal is appealing against the tribunal decision. And they decided to overturn that ruling. So that is sort of indicative that any form of cancer is likely to be deemed a disability. It doesn't have to get to the point of significant adverse effects, and there shouldn't be, because the principle behind the law is to protect people with it, it shouldn't be some minor argument about, you know, cells and precancerous lesions and this kind of thing. Now, I've put constructive knowledge in there just because I thought that there could be an issue around disclosure, because a lot of people in a lot of areas, not just this particular condition, are worried about disclosing things in their workplace that might put them at a disadvantage, might see them as vulnerable, but might lead to unfair treatment for whatever reason. Now, what I would say is disclosure is really useful, because when the employer knows that there is this issue, then the rights have to kick in. And I'll come on to some of those rights around reasonable adjustments. But there is this thing called constructive knowledge of a disability. And that is where an employer could have been reasonably expected to be aware of the disability. And by that, what they mean is, I don't have to wear the T-shirt and wave the flag to say I think I'm disabled in order for my rights to kick in. If the evidence is there that I have a substantial long-term adverse effects condition, or that I have a condition that's covered from the point of diagnosis, such as cancer, then they have the knowledge, so should treat it accordingly, which means that my employment rights should kick in. And the key one, I suppose, around disability is reasonable adjustments. One of the most common claims for disability discrimination is that reasonable adjustments have not been implemented. Now, when there is someone with a disability in the workplace, the employer has a legal duty to offer reasonable adjustments. Now, there are normally three elements to a reasonable adjustment. And they apply in situations where a person would otherwise be placed at a disadvantage compared to people who aren't disabled, essentially. The first requirement might be, or the first element might be, does it change the way things are done? So does it change a practice or a process? And an example I often use is car parking. There might be a car parking policy that only senior managers get a car parking space. Well, it may be reasonable to change that process if you have mobility issues, for instance, that kind of thing. So is there a process in place that needs changing? The second element is, are there physical features of the workplace, so physical barriers that need overcoming? And that might be a change to doors or access points or whatever it might be. So is there a process? Is there part of the physical environment? And the third element is, do they have to provide extra equipment? So assisted software or something. Now, the vague bit of reasonable adjustments is reasonable, and it's a word that the law seems to love, but it doesn't help because it's not very specific. And in reasonable adjustments, it depends upon the size and the available resources of the employer, essentially, as to whether it's reasonable. So, can't stipulate enough, it's a case-by-case approach. What's a reasonable adjustment for one person with one employer may not be for another one. So just because it's happened somewhere doesn't mean it should happen everywhere. Needless to say, if it's two people running a business, there's less of an expectation than if it's a multinational global organization in terms of the adjustments that they should be able to make. I thought I'd touch on some elements that are particularly pertinent in terms of COVID. And as I say, what I'm going to talk about next is relevant as of September the 15th, 2021. In general, complying with health and safety obligations, and that's why I've mentioned Section 44 of the Employment Rights Act, because I'll come on to that. Complying with those health and safety obligations might involve employers considering if employees can work from home and the business can function properly, it may be safest for them to do so. If employees can't work from home, but they can still travel to work, then maybe they can do that, but the employers have an obligation to then ensure that the workplace is safe. And there'll be a particular emphasis on risk assessments, not just undertaking one and having it in a folder near the door, but having one, implementing it and maintaining it to make sure it's operational and reviewing it. So things around hygiene, cleaning arrangements, social distancing, that kind of thing. Now, clinically vulnerable people might feel it's unsafe to work outside their home. First thing to do is speak to the employer. Ask the employer, can they reallocate tasks? Can they provide equipment? Can they amend job roles so that they can be performed in the house? Obvious, I know, but there are questions that need asking. Vulnerable people might be at higher risk for severe illness, and again, might feel it's safer that they don't go out. And their perception is important, and I'll come on to why that is. Can the employer offer the safest available workplace and the safest available roles in those workplaces whilst maintaining safe measures as identified in the risk assessment? The Health and Safety Executive website is better than the ACAS website in terms of risk assessments, so it's worth looking at if you want to see if risk assessments in your workplace are compliant. Can social distancing measures be maintained? If not, an employee needs to think, particularly if they are defined as disabled in terms of the Employment Rights Act, need to consider, does returning to work present an unacceptable level of risk? And employers need to reasonably consider the impact of the disability on health and safety. Are there any measures that need to be put into place and implemented to assist a disabled person? Reasonable adjustments. Now, the reason I talk about it's important to consider a vulnerable person's perception of whether it's safe or not is because Section 44 of the Employment Rights Act, I'm going to read it out because I can never remember the exact wording. Section 44 states, in circumstances of danger, which, and this is the key phrase or one of them, the employee reasonably believed to be serious and imminent, and then it goes on, and which they could not reasonably have been expected to avert, they left or proposed to leave, or while the danger persisted, they refused to return to their place of work or any dangerous part of their place of work. That's the first part. It also says, or in circumstances of danger which the employee reasonably believed to be serious and imminent, they took or proposed to take appropriate steps to protect themselves or other people from danger. So there's two elements to section 44. Reasonable belief, and you'd have to demonstrate reasonable belief. A lot of people are quoting section 44, but there has to be there has to be some element of evidence in what you're saying. If it's a vague feeling that returning to work is going to be scary, that's not necessarily a reasonable belief in the eyes of the tribunal judge. You've got to demonstrate why. So you'd have to look at what steps are in place, how safe is the workplace, and why does that lead to a reasonable belief? And then the other part of that is that you're likely to be put in serious and imminent danger. Now, if you've got cancer and you meet the disability definition, which you would by default by having cancer, the serious and the imminent bit may not be as difficult or onerous to evidence as the reasonable belief. I hope that makes sense. Two elements to it: reasonable belief and serious and imminent danger. But it's about the employee's perception as much as it is the employer's perception. A tribunal would look at, okay, did you enter into talks with the employer? Did you discuss your reasonable belief? Were steps taken to accommodate your fears? That kind of thing. Now, as well as section 44, I mentioned discrimination. So you're protected from discrimination if you're in one of those protected characteristics. So you shouldn't be put at a disadvantage because of disability. There's direct discrimination, which is I'm not employing you because you have a disability. And indirect would be I've implemented this rule and it applies to everybody. However, it has the unfortunate consequence of discriminating against people with a disability. So it may not be intentional, but it has the impact and the effect of discriminating. There's also associative and perception. Now, associative is an interesting one, but by far not straightforward to prove. But that is, I'm not being discriminated against because I'm disabled, because I'm not disabled, but I care for someone who is disabled. So the law protects me from being discriminated against by my association with the person with a disability. And there have been cases where carers for people with a disability have argued discrimination and have won constructive dismissal cases because they've argued that their discrimination is based purely on their association with someone with a disability. Now, discrimination by perception might be, I'm not going to employ you because I think I can tell you're disabled. It's irrelevant whether I am or not, but their perception is the element of the discrimination. Also protected from harassment. So that's unwanted conduct that creates an offensive, intimidating environment based on my disability. Also protected from victimization. So if I raise a complaint or assert one of these rights under the Equality Act, I shouldn't be then put at a disadvantage or what we call suffer a detriment. So be demoted or be managed out because I've raised that complaint. That's the employment rights, employment law definition. Now I've put cohabitees and carers on there and associative discrimination because, as I say, it is something that could be explored, but it's difficult because the right to reasonable adjustments covers the disabled person, not the cohabitee. But if you do believe there are grounds that you have been treated less favourably because of your caring responsibilities, then it is something to explore. What I would say is legal advice on constructive dismissal, on associative discrimination, on any of these challenges, really, you benefit from legal advice, but I get that comes at a cost. But from something like associative discrimination, you would need legal advice. And I briefly mentioned that mask wearing on there because mask wearing has come up and people have been dismissed and the employers have been, their decisions been upheld because they refused to wear masks. What I'd say was, if you've got a disability, does wearing the mask cause you a detriment? Does it cause you a problem? How significant is that problem? And again, there's a conversation to be had with the employer. Now, I also mentioned traveling to and from work, because use of public transport could be an area that puts people at risk. It's not always clear whether travel to and from work is seen as an extension of the workplace. I have seen cases where it has been deemed an extension of the workplace. So not being able to travel to work or being discriminated by the method of travel to work has been covered under discrimination law. I've seen others where it's not been that straightforward. So it is quite fact dependent. But again, if the travel to and from work, so if the workplace is safe, but the travel to and from work isn't, and there's no alternative put in place, you could argue that you're being put at a disadvantage because of the travel to and from work. It's something to consider. What I would say is all cases are fact dependent and quite specific. So it's a case by case basis. So some rules, some case law rulings exist, and it doesn't mean that every case that's based on associative discrimination will follow the same course. They're all very fact specific. I'll just put the next slide up because it may be useful to see what other forms of support are available. Now, this is a general slide that talks about ACAS services. But what I will say is mediation is one of them. ACAS website, it's got the ACAS website on there, which is useful starting call for good practice and basic employment law. But also the helpline is useful, 0300 123 1100. Employees and employers can use the helpline. What ACAS can't do is represent parties, so we have to be careful not to be seen to be biased. We're a Crown department, so we sort of civil servants, so we have to be seen to be independent. What we can do is explain the risks based on current law, existing law, case law, that kind of thing. So it's always a useful starting point, whether or not you're an employer or an employee. And what I will say is if you're in the unfortunate position of going to a tribunal, and I say unfortunate because they take a long time and they can be stressful, you will be asked if you want what we call early conciliation. And that's a case where an individual conciliator from ACAS will contact the employee or ex-employee, as is often the case, and the employer or former employer, and try and facilitate an agreement between the two parties. That can last for up to 6 weeks, but we can intervene at any point. And some of the employment tribunals now are taking, depending on how complex they are, 2 years plus to get to a hearing. And that's not been helped by the backlog from the fees, but also the backlog due to the pandemic as well. Other than that, we do have a newsletter. We are available on social media. And that, I believe, is, in a nutshell, my overview.
Thanks, Simon. I think you have covered a variety of issues that people are already interested in. So hopefully many people feel that the questions have already been answered. Do you mind if I know we sort of had an order of things we wanted to discuss, if we skip straight to the carers' rights section, because that's what's come in through the chat mainly, is people asking about whether they are, with the return to the office, etc., and COVID, whether they have a right to ask for changes as someone who's a member of a household. I think we covered that by saying that reasonable adjustments don't apply to that group of people, if I've understood you correctly. And if I have, how do people then have the conversation if it's not enshrined in law as a right, but they're still concerned?
It is a difficult one. From a best practice point of view, we'd recommend talking to your employer. If you've got trade union support, we'd recommend consulting with the trade union. If you've got an employee assistance program that many people do, some offer legal advice, so you can get legal advice that way. But a reasonable employer will take a consultative approach and try to accommodate concerns. So it's not you that's being put in danger in terms of your disability, and yourself, you're not deemed disabled. So it is a tricky one. There is that protection under associative discrimination from unfair treatment. And as I say, there are cases where people have challenged that on the grounds that they are carers of people with a disability, and they are very difficult. They are very difficult. It's as much about good practice, and it really does depend on what approach the employer takes for a partner or a cohabitee of someone with a disability. It really does depend on what approach they take. It might be that you have to take legal advice depending what it is. If there are certain scenarios that people have, then maybe I can advise. But in general, there's not a lot other that I can say.
That's fine, thank you. I hope that's given a few people in the chat a next step.
What I will say is, while I remember, sorry,
That's fine.
there is time off for dependents and that kind of thing, which I could cover, but that is limited to unforeseen sort of emergency scenarios. And a lot of what we're talking about isn't an unforeseen emergency scenario. So that is then, to an extent, falling back on the goodwill of the employer rather than any protection in law. But the case that I do know of was someone who was repeatedly put in a disadvantaged position compared to people who weren't caring for people with a disability, which is why I say if you've got specific examples, because if it's everybody has to return to work because there is no working from home, and you're a carer or a partner of someone with cancer, for instance, but everybody has to return to work, the employer just has to show why they can't accommodate you in terms of perhaps a flexible working request. And in terms of because you can make a flexible working request, assuming that you've got 26 weeks employment service and you've not made one in the previous 12 months. And home working would be a flexible working request. Now, the problem with that is there are currently about 8 or 9, I think it's 8 valid reasons why the employer can refuse them. And there are things that are quite vague, like cost, and would involve restructuring the organisation, or not the appropriate level of work to sustain. Have in showing that that's the case, because you can challenge if it's not a reasonable reason for refusing. You can challenge that. Now, employers are in a slightly more difficult position now, because for the past 18 months, there seems to have been a home working pilot that everybody's had no choice but to take part in. And that has demonstrated all across the country that a lot of jobs, a lot of roles can be undertaken from home. So if they were undertaken from home before, why can't they be now? If, though, someone's been furloughed because it's the kind of work that can't be, then there's the problem where it really does depend on the intricacies of the scenario to see how you can unpick that and see if there are any additional legal rights.
So you talked there about the employer having to show these things. So what do you mean by show? Do you mean they have to write the reasons down in writing? And you mentioned that you can challenge them, but how much are they supposed to give you reasons wise for example, rejecting a flexible working request? That first time that they say no, what are they supposed to say?
Well, in the past, it's benefited employers quite a lot, and I don't know how it's going to change, because we've been waiting for the past 2 years for an Employment Rights Act, and in the Queen's speech it said that flexibility, it was going to be flexibility by default. So we expected that the reasons for refusing flexible working requests are likely to be amended. The problem is there hasn't been an Employment Rights Act. So under the current Employment Rights Act, the employer needs to evidence that the costs are prohibitive. For instance, if they're using that as the reason, they need to evidence that there isn't sufficient work to sustain that role from home, because that's the quite loose definition. If the definitions for, or the criteria for refusing flexible working requests are tightened up, then that will change. But the minute and there aren't that many cases, I think, that challenge refusal of flexible working requests. Generally, it's seen that the right is there to ask for it, and if they don't let you ask for it or don't even consider it, then you can challenge it. But most employers are considering it and then saying no, as long as it sort of ticks one of those 8 boxes almost. So it's a difficult one.
Great, thank you. I think, oh, someone's asked a follow-up question that might be pertinent right now, actually. What if someone else is able to do the same job working from home, but the person who is disabled has not been allowed to work from home? Is that a clear-cut scenario?
Well, if it's the person who's disabled, that's different. If it's the person who's a cohabitee with the disabled person, that's where you get into this territory of that constructive dismissal case, where you've got a comparator.
Yeah.
So you can say, actually, this is unfair because you're applying to me saying you can't accommodate that. But I always, for some reason, I always say Gladys or Doris. I don't know why. But Gladys here is able to. How is that fair? What are the differences? And then they're in a different position. And I don't know if there'll be a legal precedent set where it gets challenged because of the past 18 months. And that's why there's a health warning about the advice we give today, because this is so fast moving. And there are cases in the pipeline at the minute that are COVID related that are affecting case law, which is why that has to be with quite a health warning. But if there is someone there who isn't associated with a disabled person being treated more favorably than you, what you have to demonstrate is what we call prima facie evidence of discrimination. So in the case where the lady won, it was because of comments that were made in management meetings about her being awkward, about her being a pain, about her always having time off, these disparaging remarks. So there has to be some form of prima facie evidence. You can't just say, because I'm caring for a disabled person, I'm therefore being discriminated against. But if you've got some form of prima facie evidence, the burden of proof then flips to the employer. They have to then prove they've not discriminated against you because of your association with someone who is disabled. Did that make sense?
It did to me. Hopefully it did to the person who asked the question. If not, I meant to say at the start, it's a good time for me to say it, we will make this available afterwards so people can reread it. Oh, someone said yes, it did. Good.
Brilliant.
There you go.
At least Malcolm's understood me.
Yeah, good feedback. Right, let's have a look at some of the other questions we've had then. Oh, there was another one on this topic, but it was specifically about parents of children diagnosed with leukemia. Now, my understanding is parents have some specific rights in law regarding their children, but I wondered whether you could comment on that and whether, you know, they get any specific rights when their child has been diagnosed with leukemia.
Yes. There is time off for dependents, which I can talk about. Now that is, as I say, that is more around unforeseen circumstances, because you're allowed a reasonable amount of unpaid. Now again, the health warning is check your contract, because a lot of organizations where it comes to parental leave and time off for dependents will offer at least a part of that period will be paid. So check your contract. But the statutory minimum is you're allowed time off, reasonable amount of unpaid time off to deal with sudden or expected emergencies. And for that, the employee needs to tell the employer the reason for the absence and how long they expect to be off. There's no minimum length of service. And if it's something that is foreseen, the employer would expect you to make other arrangements. This is the problem on this one, but I'll just touch on it and then I'll move on to parental leave. So there's no minimum qualifying service. So everybody's, it applies to everybody from day one employment. It's automatically unfair dismissal, or if you're selected for redundancy or dismissed, it's automatically unfair. It's classed as an automatically unfair dismissal if you're sort of dismissed or put forward for redundancy, for leave as well. I've just had a warning flash up telling me my internet connection is unstable, so let me know if you can still hear me.
You cut out for a moment just before, just after you mentioned unfair dismissal, so I wonder whether you want to go back a bit. That's where I lost you, just in case.
Yeah, okay. So if you assert that right for time off for dependents, it's automatically unfair if you're dismissed for doing that, if that makes sense. And you shouldn't be selected for redundancy for being a pain, basically, for asserting these statutory rights. And it is one of these things where there's a 3-month time limit. Now, parental leave, we have to be careful here because it's different to shared parental leave. There are two different things. Shared parental leave is sort of a variation of maternity leave. Yeah, it's around newborns and sharing that kind of leave. Parental leave is the right to take time off. Oops, hang on, my screen's gone funny. The right to take time off to look after a child or to make arrangements for their welfare. And again, it's unpaid unless your contract stipulates otherwise. Now, you need to have 12 months length of service. So you need to be working for the employer for 12 months, and you need to have the status of employee. Some people may have status of worker. You need to check that. You can check on our website about employment status. The child has to be under the age of 18, and you have to have your name on the birth certificate or the adoption certificate or some evidence that you are the legally responsible parent for that child. Now, you're supposed to give 21 days notice to the employer, which is why this isn't good in emergencies, but you can see how this works with dependency, time off for dependents. So time off for dependents, you can use for emergencies. This you could then use when you've got the notice if you give notice at the same time. So technically you're supposed to give 21 days notice. The employer might be more lenient. Most are. You can take 18 weeks unpaid parental leave for each child under the age of 18. There is a limit to how much you can take in one go. I think it tends to be around 4 weeks in a year for each child. Again, unless your contract stipulates otherwise. It's taken in blocks of a week unless your child is classed as disabled, which if they had leukemia, there would be, in which case you can take it in days rather than weeks. And that week is the week you work. So if you only work 3 days, you only take 3 days as your week, if that makes sense. One of the difficulties is the employer has the option to postpone it. But they have to give you 7 days notice of your initial request, and they have to give you a new date when it can happen, and it has to be within 6 months of that request. And they can't change the amount of leave. They can't say, well, we'll only give you 1 week. And when you return, if you have a substantial period off and you return, if you return within 4 weeks, you're supposed to be guaranteed the same job back. If you return after 4 weeks, you're supposed to be guaranteed the same job, or if that's not possible, a job with no worsened terms and conditions, if that makes sense.
So all the stuff you've mentioned is fairly short term, as in we're talking sort of up to 4-week blocks there.
Yeah.
Do you have any advice for people who are, I mean, leukemia treatment can go on for years. Is there any protection, or do you have any advice for just having that conversation with the employer about how long you're going to be away for?
Yeah, the problem with working with ACAS is you see the problems all the time. And there are a lot of employers out there who aren't that problematic and take quite a consultative approach. And a good practice approach is working with your employer to have a meaningful conversation to see what options are available for you. Because it might be that you have to take a flexible working request. It might be that you have to change your working pattern. It might be that you can change job role on a temporary basis, but you'll find out by having that conversation rather than assuming that it's going to be a no. And I can understand why people think simply by having the conversation they're putting themselves in a difficult position. But there is that associative protection, remember.
We lost you for a moment there, but I think you're back. Can you hear me okay?
I can hear you.
Yeah, I caught the end of your sentence.
I can see and hear you, but
I think we're
how
all
much
good.
did you miss? Okay.
I don't think we missed anything in the end, hopefully, but if anybody's got any follow-up questions, please do let me know. I hope that's helpful for the person asking about parental leave. The next most common question I can see in the chat is reasonable adjustments. So I think we'll move to that section if that's all right with you, Simon. Someone in the chat box has asked whether reasonable adjustments have to be temporary or whether they can be permanent. And they've given an example of working from home, but obviously there may be others. Do you have any thoughts on that?
I wish I could give an answer. There is no clear definition of how long they last, because this whole fact dependent thing falls into play. And again, it relies on the resources available to the organization. I have seen adjustments where quite a senior member of staff has taken a less stressful role because it helped their mental health and that aided their return to work, but they kept their higher grade pay. And they did that for a long period of time because the employer could sustain it. I've seen others where they've said this was only ever a temporary reasonable adjustment. We knew that from the beginning and we can't accommodate on a permanent basis. So it really does depend on the organisation. I'd say the greater chance you have is if it's a larger organisation with more resources available, basically. But it doesn't have to be temporary. And it doesn't have to just be one. They can change over time. They should always be reviewed. It's about, at that moment in time, is this adjustment necessary to stop you being put at a significant disadvantage? And it could be a different adjustment in 6 months' time.
I think there's also the challenge of not all employers understanding that some types of leukemia are chronic and long-term and incurable. And I know a lot of our participants listening are probably in that boat. So is it worth them, when they're making the reasonable adjustment request the first time, is to give some indication of whether they expect it to be a long-term problem or not? So for example, fatigue is something that people experience almost forever, if you like, and if there's an adjustment to deal with that, should they be honest at that point that they think it may be a long-term thing?
If they know it will be, then there's no reason not to, ideally. Basically, both positions would need to be supported by evidence. So the employee, or what I'd say is any employer should be talking to the employee and saying, what are the adjustments that you need to be able to do this job? But backing that up with, say, an occupational health referral or some sort of specific needs assessment or consultant's advice. The more evidence it's based on, the sounder basis for the judgment. So yeah, by all means, tell them that, because if you don't tell them that, chances are occupational health will indicate that. And make the occupational health referral work for you as well as the employer, basically. Suggest an occupational health referral and be honest with the occupational health. But there's an expectation that the employer will be open-minded about this as well as the employee, given the sensitivity of the situation that they find themselves in, obviously. But there is that expectation. So it might get better, it might change. It's about setting a time to review it, put it that way. But yeah, I'd recommend honesty and transparency on both parts.
Great. And since you mentioned occupational health, someone again in the chat has asked, has said that they've had an occupational health and assessment, but the employer doesn't agree with the recommendations. Is that something that they have to adhere to?
That's an interesting question, because it goes back to the evidence thing that I mentioned. Their decision, they have to be able to support their decision. So occupational health, fit notes, all these things are advisory. A fit note isn't legally binding, but if an employer is making a decision contrary to all the evidence, they've got to be able to support it. So I've seen cases where employers have decided that the person doesn't meet the definition of disability because they had one rogue occupational health referral that said that, and they had all this other evidence that said, no, it definitely meets the definition, and they went with the one that suited their argument, and clearly they lost the case. It's that balance of probabilities thing again. The employment tribunals are quite pragmatic about this. So if it is very risky, they can ignore it. But it's very risky to do that. They're opening themselves up for litigation, because what are they basing their decision on, if not the evidence before them?
So the person has actually added that they have been put forward for redeployment as an alternative. So I guess our advice, if you like, to them would be to challenge the initial decision not to listen to occupational health, if I've understood you correctly.
I would, rather than saying challenge it for not listening, I would say, what's that decision based on?
Mm-hmm. Great.
What have you based your decision on?
I hope that's helpful.
And then look, if it's unfair treatment or some form of discrimination, then
yeah,
you know where to go.
Great. Just looking at the other reasonable adjustment questions, people have asked about specific reasonable adjustments, but I think you've covered that in your presentation, that there is no reasonable adjustment definition. It could be anything, and on a case-by-case basis. Is that right?
Yeah, and as much as I'd like to give people definitive answers, ACAS aren't in the position where we can say, well, that's classed as reasonable, in the same way that we can't say, yes, you've got a sufficient case there for constructive dismissal. We can't give those definitive answers. We can just tell you balance of probabilities, what the risks are, that kind of thing.
One of the questions we had in advance on this, it was around sort of mentally coping with a diagnosis and whether the time off for that was a reasonable adjustment or not. Do you have any thoughts on that? I guess it comes into sort of a mental health issue as well as a physical issue.
Are we talking about the person for whom the diagnosis exists being able to cope with time off because of?
It suggests that they feel they need some time off to come to terms with their diagnosis. Yeah, if that makes sense. So mentally come to terms with it rather than physically.
Well, I've seen reasonable adjustments around depression and anxiety where people have reduced their time at work or worked from home on reduced hours to facilitate a longer term return to fuller hours, and they're reasonable adjustments. But again, it depends on the organization. I know time off to attend appointments. There are cases that I've seen where time off to attend appointments, that kind of thing, is deemed a reasonable adjustment. So it doesn't affect their pay and it helps them accommodate what they need to deal with. So in theory, it could be.
Great, thank you. And a couple of people, both in advance and on the chat, have asked what happens if they can't go back to work during the COVID pandemic at the moment. So they've had advice from their doctor not to return. They've been on one of them has been on furlough, the other one doesn't specify, but they're asking what is the next step. If there's no adjustments, they're not going back, do they have to resign at that point, or is there further talks to be had?
So this is an employer who cannot work from home after furlough?
Yes.
Can't offer home working?
Yeah, they said well, one is a teacher and one is a nursery teacher, so you'd assume there's no sort of option for working from home there, based on their profession.
Yeah, it would be a case of evidencing your concerns and why a return to that workplace puts you in significant imminent danger, basically, rather than assuming it will. If you can show, because what the employer's got to do is meet you in the middle and say, okay, here's our risk assessments, here's all the steps we're taking, we're following NHS advice, we're following gov.uk advice, we'll maintain social distancing, we've got cleaning stations, all these things. And if they still are not comfortable and there are no alternatives, the employer then, if you challenge that, say you were being put at a disadvantage because of your disability, the employer might argue they've got an objective justification because they've got no alternative. But they can only do that when they've explored all the available options. If there are still options available that they're not willing to explore, like, oh, it's too much admin, you know, they're putting themselves in a risky position. But if they've genuinely consulted and explored all the available options and they still cannot accommodate it, then you're in a difficult position, because employer might look at dismissing because of attendance management issues. Some employment lawyers advocate, this is not an ACAS line, but will advocate, what's the word? Without prejudice conversations. So entering into an open, honest conversation about, okay, well, what can we do? Give me a settlement agreement. If you're going to dismiss me, I'm going to take you to the tribunal under discrimination, but obviously in far more accommodating, constructive terms than that. So it may be a case that you can look at, you know, coming to some sort of settlement agreement. What I would say is, our helpline could give you far more specific advice if we have a longer one-to-one conversation about this, in terms of what the scenario is, what the risks are, what the employers tried to do to accommodate, that kind of thing.
Great. What I'll do at the very end is make sure we're clear what you should come to us at Leukaemia Care about and what ACAS are better advised to deal with. And I think specifics such as that is probably much more helpful for you to go direct it to ACAS when such a specific scenario. But we'll go over that details at the end, definitely. The last question on reasonable adjustments that we had before we came in was a guy who suggested a reasonable adjustment and went to the effort of having it funded through the Access to Work scheme, but it was then rejected by the employer. What are his options there?
Appeal against it. I'd raise an informal complaint and say, okay, so we've agreed this reasonable adjustment. It seems reasonable. On what grounds have you rejected the reasonable adjustment? Are you aware that it could constitute discrimination in terms of failure to make reasonable adjustments? Failure to make reasonable adjustments is one of the most common causes of disability discrimination. Either the employer doesn't have knowledge of the disability or claims not to, and it's found against them, this constructive knowledge of disability, or they've simply not identified the adjustments, or they've identified the wrong adjustments. I've seen cases where people have put in different adjustments that they wanted, not the ones the employee wanted, and it's gone against them because they could have accommodated the employees, they just decided not to. So on what grounds? They've got to have an objective justification for not implementing that reasonable adjustment. What is the objective justification? Would be my argument. And it'd be interesting to see what it was, if it's been funded, so resources aren't a problem. Do we know what the problem was?
I do, but he hasn't given us permission to say, but I can take that offline and see if we can.
Yeah, no, that's fine. No, that's fine. Sorry.
That's okay. I just recognise the story from having worked with the
No, it's not a problem.
I wouldn't want to say details. I don't know if he's here. But that's some really helpful advice. Thank you. I think we've covered all the reasonable adjustment questions either in Simon's presentation or from the chat. Some advice on where to go next, but do shout to me if that's not the case. It's been very popular today, so I'm trying to follow your questions as best I can. Just a few other questions that we could cover then, going back to sort of the very beginning. What about talking to an employer? So you mentioned that you think disclosure is good at the point of diagnosis or at the point of joining an employer to make sure you can't have your rights upheld unless someone knows that disability exists. But I mean, how is it best to do so once you've been diagnosed with leukemia? Like, people are often worried about being singled out by disclosing their disability. Do you have any further advice for someone worried about telling people?
Yeah, I understand the pressures on people not to disclose. I understand the reasons why, many of the reasons. I can't possibly understand all of them as to why people might feel in a vulnerable position not wanting to disclose. And there is this idea of constructive knowledge. The problem is, if you know you have a disability, or it would be classed as a disability. I don't want to label things as disability or not, but in the eyes of employment law, it could be classed as meeting the definition of a disability. And you're not disclosing it, it could jeopardize your ability to fully appreciate the weight of the law, I suppose, if you want to put it that way. I'd be tempted to have a recorded conversation, when I say recorded, note take or whatever, formal conversation with the employer, so then it's documented. Because once it's documented, it's there, and that helps you either with in terms of, okay, I think this will be treated, I'll be treated differently because of this, I'll be treated unfairly, I could be put at a disadvantage, I could suffer a detriment. If it's a conversation that you know is on your personnel file, that sort of protects you. So if it's an informal chat, that's fine, but what happens next? If there's an occupational health referral about adjustments in the workplace, that'll be recorded. So once it's formalised and it's on record, the paperwork's there. And you can make subject access requests, that kind of thing, if you need to challenge it at a later date. But once it's sort of in writing, then you started the ball rolling in terms of not just implementing your rights, but protecting yourself from any disadvantage later on.
Yeah.
And there are cases where people haven't made it clear and haven't wished to admit that they've got a problem, although this relates to someone with schizophrenia. And when challenged at a later date, it went in the employer's favour simply because this person refused to share, wouldn't give consent to the occupational health, wouldn't take part in that dialogue, and that prevented the employer from taking the action they then criticised them for not taking, if that makes sense.
Yeah, absolutely. I think you make some really important points there about, you know, it's all well and good worrying about bad things that may happen, but it's also worth protecting yourself by having a formal conversation rather than an informal one.
Yeah, I think it's easy for me to say, but I think the benefits sort of outweigh the challenges. But as I say, it's easy for me to say, so I understand why people are reluctant.
Yeah. And then I guess there's a different scenario where perhaps someone living with leukemia long term has returned to work and maybe there was no adjustment, and they want to talk about new challenges they're facing, and they're worried about expressing new difficulties later down the line in case that means that they'll be seen as dispensable, I guess. Do you have any advice for sort of conversations later on in your sort of diagnosis journey?
So this is someone that's shared a certain amount and is concerned about maybe making matters worse in terms of how much of a problem they're seeing in the workplace or something, making themselves more vulnerable by sharing.
Yeah, so they've been diagnosed and they may have continued to work, and now they're finding things difficult. Maybe they've got a new side effect or something like that that's just popped up. How do they, talk about how they're not coping at the moment?
Well, they're still protected, the same employment rights, so they shouldn't be discriminated against. They shouldn't be dismissed on the grounds of the disability. They shouldn't be picked for redundancy on the grounds of the disability. So all those rights are still in place. It's not for me to tell somebody how much that they can disclose and they're comfortable to disclose, but from an employment good practice point of view, the more open and honest both conversations are, the more reasonable both parties are acting, the better the outcome, if that makes sense.
I think you cut out very, very slightly. Do you want to just repeat that last sentence for me?
Yeah, I think what I said was, from a good practice point of view, the more open and transparent and consultative both parties are, the more reasonable both parties are, the more successful the outcome's likely to be, the more effective the outcome's likely to be. Obviously, it's different if your past experience is telling you that you're already being put at a disadvantage, in which case I'd make sure I was recording everything and documenting everything. Because if you want to challenge it, documentation, evidence, can't say this often enough, evidence is key when it comes to a tribunal. So all these little instances, even if they're sort of 1,000 paper cuts, whatever the phrase is, all these little instances that you are being put at a disadvantage, document them all.
Great. I'm looking through, and I believe we've covered most of the questions we had prepared and all the questions in the chat. So I'm going to give a warning to everyone that this will be the last question unless someone pipes up now, your final warning. But the last question I can see that I think we haven't covered is about returning from furlough specifically. Now, this probably isn't blood cancer specific. It's something that could apply to lots of people about to return from furlough, but can an employer make changes to their working days and pay? So essentially someone's contract returning from furlough, is that possible?
Well, there's been a lot in the press about fire and rehire, and that's always existed, but for some reason it's now become a political hot potato. Essentially, you're looking at a variation of contract. Furlough itself was a variation of contract, even if it was a temporary one. So it should have been done by agreement, preferably in writing, and preferably very specific. So you can vary contracts in a variety of ways. It should be done by agreement after consultation. So these are our plans. This is what we're looking at doing. These are the reasons why we need to change. Can we get you to agree? That kind of thing. Because the alternatives are imposing it or firing you and rehiring you. And for both of those, you could look at a breach of contract or unfair dismissal. You could resign and claim constructive dismissal if you've got 2 years service. So unfair and constructive are 2 years service. And for constructive dismissal, you have to show there's a fundamental breach of your contract, which there would be. That breach caused your resignation and there wasn't a significant delay between the two things. So if there's a breach and then you think about it for a period of time and then resign, the longer that period of time is, the more difficult your case is in terms of constructive dismissal. Now you can stay in post under the new terms and work under protest, but you need to inform the employer that actually you're not happy and I'm working under protest. Preferably, again, do it in writing so everything's documented and you've got an audit trail. The problem with working under protest is rather than going through an employment tribunal, you'd have to take court action in the civil courts, so you'd need legal advice. But you can look at breach of contract definitely for contract variation if there's no agreement. And if they're doing it to lots of people, so if there's 40 people who are being dismissed and rehired, then you move back into the territory of, is this a redundancy? Because there's a diminished need for that work. And we've dismissed more than 20 people. So are we consulting and does it fit the right timescales? So all sorts of rules kick in then. But you can definitely challenge it because the contract doesn't have to be in writing. The binding contract is you offer me terms, I agree them. So whether it's done verbally or in writing, the problem is obviously if it's not in writing, it's difficult to prove. But the breach of contract is the binding agreement between two parties. So if you're going to tear that up and change it at will, it's not really worth a lot. So you can definitely challenge it.
Great.
Seek advice. Phone the ACAS helpline. Drop me an email. Whatever it takes, you can definitely challenge that.
Great, thank you. Someone's pointed out I missed a question, thank you. It was about the tribunal and what the outcome of a successful tribunal is. I suppose that would depend on what the claim was, but do you have any sort of general comments to make on the outcomes of tribunals?
Yeah, it depends on the jurisdiction. So what protected right you're challenging. And for things like discrimination, they can be well, for unfair dismissal, quite often you get loss of earnings and injury to feelings. The loss of earnings bit, you have to demonstrate. So if I'm out of work, for instance, if I've been dismissed and I want to claim loss of earnings, I've got to be actively seeking work, almost like claiming job seekers allowance or universal credit. I've got to demonstrate that I was looking for work in that period. I can't just see that as, okay, I'm going to sit back, challenge this and see what I get. So you have to demonstrate, and you have to a schedule of loss. You have to demonstrate what your losses are. Injury or feelings, anybody's guess. In terms of discrimination, it could be anybody's guess. Now there are what they call vento bans, so they'll classify them as I don't know what the exact phrases are, but in terms of severity, there are different vento bands in terms of what the caps are. So some jurisdictions, in short, some jurisdictions have caps on what the remedy, the financial remedy, so how much you'd get paid. And you can look those up on the internet, or we can give advice at a later date on what those actually are. But generally, you're looking at compensation for loss of earnings or injury to feelings, that kind of thing. Unless it's something specific like consultation in redundancy not being meaningful. If you challenge that and won, then the protected award is 90 days pay. That's the maximum, but it starts at the maximum. You don't work up to the maximum. It's seen as a punitive measure, so it's punishment. So it's 90 days for each employee, and then the employer has to argue it down. So it's different for, like, as you say, different jurisdictions.
Great, thank you. I think I have now covered everything, and we are at time anyway. We've managed to fill a full hour and a half on this. Thank you, Simon, for all your advice. Yes, it's a popular topic among our patients. I hope everyone's found it really useful. Thank you for participating. I want to say, if anybody still feels that we haven't answered their question, do get in touch with either us or ACAS, and I'm sure we will all manage to find you the answer. I'm just preparing our final slide. I'm having some internet issues myself now, which is a little frustrating so late in the day. I wanted to share some numbers and things before everybody goes. Here we go. I think I'm in business now. Okay. So just wanted to take the opportunity to remind you all that we do actually have an advocacy service here at Leukaemia Care. Now, we don't offer legal advice or very detailed employment advice, but if you want us to signpost you to people who can help you with those sorts of things, that is something that we can do. And if you're not sure where to go next following this webinar, we are a really good sort of first point of contact. So please do get in touch if you've got any questions. And then obviously ACAS has loads of really great information, including a disability at work section for further information. And Simon's very kindly offered to get in touch with anybody who needs further help. So if you do feel that you need further help, please let me know and I will put you all in touch. And we also have some information on our website about employment rights, which very much, sorry, these are moving without me asking them to, which very much covers the basics, similar to what Simon's already covered in his slide at the beginning, that you may find useful to read as well. Here's all our contact information for, social media and things like that, if you find that useful. Just on information sources, I wanted to point out that our next webinar is coming up very soon and is going to be about COVID vaccine updates. I'm sure many of you are really, really interested in following recent announcements. So please do look on the website for that and sign up for that one. And here's just a full list of all the support services. I've already talked about welfare and advocacy, but we also do a variety of other things if you need any support following a leukemia diagnosis. And I'll just leave this up for a moment while I thank Simon again for your time today. Thank you so much for answering some very complex questions. And I'm sure everybody will find it really, really useful now and for as long as the information is valid into the future. Thank you, everyone. Have a good afternoon.